Anna Chalenza. I'm the Kesteker Professor of Music here at Georgetown University, but the proudest hat I wear is getting to be a part of the Future of Music Coalition every year and getting to work with all these wonderful people, and also, most especially, getting to meet all of you. And I guess what I'd like to do just to start off today is thank you for being so open. A number of our students are here. They're students that are hoping to go into the music industry or into business in general. We've also had a number of students who are performers, hoping to make that path. This event is so wonderful, not only because they get to sort of see the real world and see what they're getting involved in, but also because they get to meet all of you, and you've been wonderfully supportive and willing to talk to them, and it truly has been a life-changing experience as they move forward to the next level. So thank you so much for that. And in that vein, I would like to point out a couple of professors that are here. Benjamin Harbert is a colleague of mine in the music program, also film and media studies. Is Bernie Cook here? Bernie Cook is another professor, a dean here in the film and media studies, and that will allow me to segue into my introduction of Casey Ray. In addition to his formidable role with the Future of Music Coalition, we are very lucky to also have him as a faculty member at Georgetown University. So Casey Ray.
Thank you, Anna, and good morning, everybody. Did you guys party pretty hard last night? Yeah? Well, awesome. So you should be in the perfect headspace for a legal panel then, is what I'm understanding. We've got a great guide for this next conversation. Can we get him out here? You guys filing in? Come on out here. So this guy, Walter McDonough, has been instrumental in my own attempts at figuring out this crazy universe of music and copyright. So he's one of the most compassionate and straight-up justice-oriented people I've ever met. And pro tip, if you're ever in the Boston area, you should look him up, because he will show you the town and teach you the skinny. By the end of it, you'll know where every single wait staff went to high school, what sports teams are on the up and up. And I'm glad he managed to make it to Summit because, you know, time passes and sometimes I don't see him for a while. But I figure he's just out there in the world doing good works and causing trouble in his uniquely Walter way. So I personally thank you for all the insights over the years, and I want you to bring out your guys so you can share some of those insights with these folks.
Thank you.
You got it.
Thank you. How was everyone doing? Oh, good. Hey, by the way, if I just want to say a couple of things before I begin. The first is that I was so inspired by those folks from Denver last night that I decided to wear my high school sweatshirt. And as you may not, well, there's actually been two members of the Future Coalition who went to North America's oldest school, Boston Latin, Shire and myself. But I found the people from Denver to be so inspirational last night in their mission to help kids. And living in Boston, Massachusetts, which of course is the center of the universe, it amazes me how many people in this room who visited from Boston are connected with our great Mayor Marty Walsh, who may be a speaker next year, and what Mayor Walsh is doing in Boston right now for music and the arts in all the various communities, the Irish people, the Italian people, Latino community, the African American community, the Asian community. We're doing wonders in Boston now, and it just goes to show that an organization like the FMC can create, and the mayor of Boston is a fan of the Future of Music Coalition. But it just goes to show what we can do as individuals to help music in our own community. So in Denver, in Boston, things are happening. And as you go back to your homes across the United States and Canada, you can do the same thing. So, may I begin? Casey was so kind to me to kind of invent a panel. And I decided what I would do is I would reach out to the 4 best music lawyers in the United States, and all 4 of them accepted. And I will let them introduce themselves, but there's a common theme to this panel. One is that they're, in my opinion, the 4 best lawyers in the United States, but more importantly, they're Menschers. These are 4 of the nicest people I also know. So let me begin with the story. And Paul LiCalsi is going to edit me on this, but apparently a man is in Africa. Is that correct? Was that where he was? Yeah. He's in Africa, and he is a expert. I'm going to say an orangutan. He's an expert in orangutans.
It was actually a smaller ape.
Well, I'm a friend of the orangutan community. But the thing is, so this guy's out in the savannah, and he's with the orangutan, and does anybody know the story? And the orangutan grabs the camera out of his hands and runs off, and for some inexplicable reason, the orangutan takes a selfie of himself. Now, here's the question I have, is how does an orangutan know how to take a selfie? Now, if it was an iPhone, I would understand, but not a camera. But at any rate, as many of you know, that it went to, it's been recently litigated, and it goes to the issue of authorship or copyright law, but the court ruled that an orangutan could not own a copyright, which I think is wrong.
I think that it can't be an author. An author has to be a person.
Yes.
And if you decide that an orangutan or whatever ape it was is a person, then
Well,
they'll be held to pay and no
the
fool.
first thing that came
Aren't we all orangutans?
Paul, and the funny thing was, the first thing that occurred to me was, this is like the producers who sued to own the sound recordings. At any rate, I will stop monopolizing the panel. I'd like to have each of these wonderful people introduce themselves. Would you like to begin?
I would like to begin. I'm Ashlye Keaton. I live in New Orleans. I co-founded the Entertainment Law Legal Assistance Project. Can you remember what the acronym stands for? And I'm an adjunct professor at Tulane Law School and the University of New Orleans, and have a private practice in New Orleans.
Jill Berliner, I live in Los Angeles. I'm a music attorney for decades and transactional only, so don't ask me litigation questions.
Janine Small, like Jill, also been a transactional attorney for decades. I just recently started my own firm after 22 years with one of the big guys, and I guess that's what to say. And I'm also chair-elect of the ABA Sports and Entertainment section, and I need everyone that's a lawyer to be involved.
I'm Paul LiCalsi. I'm a litigator. I've been litigating in music for a long time. I'm with the firm Robbins, Kaplan, Miller, and Ciresi, and I'm based in New York.
Good. And by the way, Janine Natta has taught me 60% of everything I know.
Janine.
I still call you Janine Natta. All right, so we're going to try to make this very colloquial and collegial, but I just want to have people talk about, these are four very experienced attorneys who've done a lot of heavy lifting for a lot of major clients, both big and small. But I want to open this up by talking about how people have seen the trajectory of royalties over your legal career. So why don't you start, Janine? I mean, how have you seen the royalties for your clients change in the last, let's say, 15 years?
Okay, so the royalties have traditionally been based on sales of records and unit sales of physical records, and they were traditionally a percentage of a retail price with deductions, for packaging and free goods, just a fiction to find a way to come up with a number. And a royalty point, let's say generally in our mind, was worth 10 cents. So it was, people were getting traditionally between 13 and 18 points, so between $1.30 and $1.80 a record. This is on the record royalty side. So a few things have happened. There was a lot of issues about transparency that happened a number of years ago, and that moved a lot of the record labels into doing more of their royalties based on a wholesale price without all these fiction deductions. So the money is similar, but it just came to a point where it was easier for people, presumably, to figure out what the money would be. Now we've moved into the world of streaming and digital, and we're less in a physical business, and I think the record labels are still trying to think in the same way about paying people a percentage of earnings, but now it's not based on, instead of, they don't have a sales price anymore, they're basing it on the income that's earned from services. So the artists are getting something like 13 to 15% of the income collected from the services. Just to back up, traditionally when there was a license, so we used that, maybe someone used a song in a film, or just a master not in a record, they were paid 50% of net receipts, and the label shared equally with the artist. So now, because the world has changed in streaming, as opposed to paying on a 50-50 basis, a lot of the record labels are trying to keep within this old confines of having the smaller percentage paid to the artist. And right now everyone's making a lot less money because the sales of records are, records aren't selling for as much as they used to be. So, I mean, a lot of the discussion is really on what percentages now people should make of revenue as opposed to royalties being done the traditional way.
So they've gone down?
And they've gone down substantially.
Can I jump in
Oh,
here for a
absolutely, please.
Okay, first of all, everything Janine said is correct. In theory, the problem is that the truth is that the record companies rarely pay at all. And what really has to happen is in order to be paid, and this is true going back to the beginning of my practice, which was 30 years ago, and it's still the case, if you really want to be paid, you absolutely, without question, must audit the companies, because otherwise you will not be paid anything at all, or at least some small fraction of what the contract arguably says you're entitled to. Also, with regard to the idea of being paid on a receipts basis, which Janine was just talking about for purposes of streaming and subscription, the record companies are still playing games. They used to in the old days, the pre all of your birth. There was something called record clubs, and back then the record companies would pay this really ridiculously low percentage of sales on record clubs, because if anybody remembers them, there was like buy one, get one free programs all the time. So the record company would argue that they hardly made anything because all the records through the record clubs were free. Well, the truth is what was happening was that the record clubs were paying the record companies a trademark licensing fee so that the so that the record club could have access to the entire catalog of the record company by paying this licensing fee for the trademark, but the record company could consider that not payment in connection with sales of records and therefore account for none of it to the artists. I suspect, and I don't actually have proof of this, but I'm pretty sure it wouldn't be hard to get, that in the subscription model, something very similar is happening. The record companies are receiving some kind of access or global fee from the subscription services and exchange giving the catalog to the subscription services for minimal, if not no.
It's what's called the breakage issue.
Right.
Right.
You're getting labels going to the subscription services, and the big labels are able to do it. The indies are getting squeezed here, but the big labels are getting either enormous advances or enormous guarantees, and negotiating very low royalties per stream, and it never gets earned out, and it's never attributable to a particular product. So they're keeping all the money, dribbling money to artists, often at less than 50-50 because they of their contracts.
I'm afraid to say this, but I mean, there's a new concept called digital breakage.
Yeah. Digital breakage. It's like digital packaging.
Okay, so let me explain breakage to those of you that don't remember vinyl. There used to be a concept in record contracts that was a breakage allocation. A&M held on to a 10% breakage allocation. I think maybe still does. I mean, the royalties were always paid on 90% because of 10% breakage, the idea being that the vinyl broke. Yet we still, okay, so that's what, when he says breakage, that's what he's talking about.
In terms of the changes that I've seen as a litigator, I mean, I get into these things after the audit is done and people litigate. And I've seen an enormous change over the years. So not only are you getting pressure from the labels in terms of what they're going to pay on and how much they're going to pay, but you also have, I think, increasing conservatism on the part of the courts in applying the law. Back in the late 80s, we had a litigation for the Beatles against EMI Capital. We were able to sustain in New York State a claim of breach of fiduciary duty, and the threat of getting the Beatles masters back. We're 180 degrees away from that. When you have in the New York Court of Appeals, the highest state court, a couple of years ago, Ronnie Spector sued Phil Spector's company for not paying her anything on master use licenses, like licensing records to the movies. And the court said, well, it's an old contract and there's no provision for paying that, so it's really unfair, but that's what your contract says.
And we had the case last week of the Duke Ellington's ears.
Exactly, and Toto a couple weeks before that.
But I think your point's well taken, though, Paul. I mean, it is interesting, and New York obviously is a hotbed of litigation for a number of reasons. But the Duke Ellington case, of course, you know the whole saga of Northern Songs. Sure. Which is a whole, we just don't do a panel, we'll do a 3-day workshop on Northern Songs. But I think you're right, though. I mean, the courts have become very, conservative is the best word to call it. And they've gone back and they're less proactive in these cases. They just said that was the contract in that point. And frankly, I think it's because they don't get it. I just don't think the expertise is there in the court system.
And you know, you get these situations. I was looking at the record on appeal in the Toto case. The Toto case involved Toto's claim that Sony should be paying it 50% on download income, and Sony
that old master use language.
and Sony went to its contract and is saying, no, the 50-50 deal is only for something called leasing sound recordings, not for sales, and a download on iTunes is a sale. And the court not only found Sony correct on that, but they also allowed Sony to apply its audiophile deduction, which is even on that rate, they only have to pay 80% because of all the difficulty in manufacturing audiophile.
That's the opposite of the M&M case then. So in California, we have M&M.
No, that's right. Well,
Which-
but it was a different contract.
It all depends
Right,
on the
on
language.
the verbiage,
Yeah.
right.
Yeah, I mean.
Yeah, this old verbiage and contracts, which back in the day when they had breakage, they had packaging charges, they had new technology deductions, they had free good deductions. When you try and apply it now to all these things, you know, people are arguing, well, does it fall under this 50-50 leasing clause, or does it fall under the record clause where now I can, you know, take your royalty in 5 different ways, reduce it, so you're down to nothing. So, you know, cases have gone different ways depending on how a contract was written.
Well, and the
Really.
courts have ultimate discretion to determine any outcome. So, I mean, you have a wide array of different outcomes with similar fact patterns. And so when when you're advising your client, it's difficult because you want to go after someone in court. We were talking on our way in, I mean, how much is it going to cost you to be right? And what does that even mean? So if you, depending on which, circuit you're in or which jurisdiction you're in, and I come from one that doesn't see a lot of these record contracts, you have a bunch of judges who don't know what they're talking about. I've had a discussion with a federal judge on the sidewalk in downtown New Orleans who told me, Ashley, I'm just really uncomfortable with the art stuff. Okay, this is a federal appointed judge. I mean, he's also the same judge in the judges' chambers when I had 17 co-defendants, and one of them was Coca-Cola and NCAA, and they settled on the same day, and there was just one who did not. And this judge said, I'm not going to read the Copyright Act. I might have one of my clerks do it. I can't do this. I don't understand it. I don't want to deal with it. And I'm going, Coca-Cola settled day one. They don't do that. This is an easy win. This is not something you have to think about. But he was so scared. There's this psychological.
It's very difficult, and in litigations, I mean, you've just got to be able to educate the bench when you're doing it. And there's another problem. It's not exactly directly connected to the kinds of royalties we're talking about, but I've done litigation in the ASCAP rate court. And, you've got federal judges whose law clerks were all brainwashed by Lawrence Lessig, and who think, technology can do no wrong, and the judge, him or herself, doesn't really know how technology works.
And I think it should be free because of Creative Commons.
Yeah. Should be free.
Everything should be free.
It's tough. You've got to be very aggressive if you're in a litigation, and you've got to be able to explain it. Explain what's really at stake to the court.
To be quite honest, I mean, I completely respect your point, but I mean, I clerked for federal judge, and the judge that I clerked for, we had like some of the Boston litigation with Donnie Engel, is that correct?
Yeah, Donnie.
Yeah, well, and that was not a good thing. he appeared before the judge at clerk for not a good situation. He beat the crap out of him. But that's neither here nor there. But
let me just be, I promised I would be the practical one on the panel.
I
For
know.
those of you in the audience that never plan to litigate, here's what you should take from this whole conversation. Have experts around you.
Yeah.
If you're planning on having a career, as soon as you possibly can, try to find a knowledgeable business manager, someone who's an accountant with an actual background in the music industry, because as you can hear, and if you're probably as confused as I would be if I didn't work in this area, it's not a rational line between a radio performance and money in your pocket. It's not something that a judge on the streets of New Orleans can easily understand, let alone a musician who wants to just play in a club. So basically make sure that you have knowledgeable representation. Get a good business manager, get a knowledgeable attorney. It's going to cost you a little bit, but it's going to pay it for itself in the long run.
Right. But I think generally the theme, though, is that, everyone here has done this for a while, and I think that people saw the CD business model where you had mechanicals and you had record royalties. Now we're in a different world with streaming royalties, which are Kristen Thompson, I don't know if anybody's had the opportunity to read the studies that Kristen has done on royalties, but the streaming royalties are negligible compared to traditional CD royalties. So I think generally the question is this. I mean, in a world where royalties have been squished, which I think is the legal term, squished, how has that changed the way you practice law, and how has that changed the way that you represent your clients? Or how does it affect the way you see litigation?
We work a lot harder for a lot less money, just like everyone else. And but the other question is, what does it do to the major record companies? Because at the end of the day, their only bread and butter is record sales, as opposed to, well, except for the ones that are now aggressively seeking 360 deals. But basically, if the record companies all crash and burn, what happens to the industry as a whole? I mean, it's kind of like lay awake at night worrying about this, or just close your eyes and go to sleep and figure it'll work itself out eventually. I don't know.
Yeah.
Well, yeah, and they're kind of becoming more marketing companies, but it is, I mean, what's happening in the business is what happened, I guess, years ago, right, when you probably started, where the record companies are getting 360 deals where they want to be your merchandiser. They want you to do a publishing deal with them. If you're lucky, you'll get a separate advance. But it used to be that an artist, they had their records, let's say more recently, because back in the day everything was combined, but you have your records with your record company, you have other income streams. So you can make money from your touring, you can have a different publishing deal, you can have a different merchandising deal. Now the record labels are realizing that they have to figure out how to still pay all the people on their staff, and they don't have as much income. So now they're saying to their artists that they're paying, when they used to maybe get $500,000 advances, maybe they're lucky to get 100,000 or 80,000, and in return, the record labels are asking for 15%, anywhere from 5 to 15% of the artist's income from all these other sources. So they're asking you to pay part of your touring and your merchandising to kind of subsidize their business, and that's been a real squeeze on income that the artist can earn, especially because the artist already has to pay a manager and an agent and a business manager and all these people on that income at potentially a gross rate, when they have to pay third-party expenses on this money. So not only are the lawyers and everyone making less than the artists, but these contracts are so much more complicated and extensive, and this is potentially the only time they're going to do a deal. No longer are there 4 deals. There's 1 deal, so that's become a real problem.
Well, the major labels back in the day, they were manufacturers, they were distributors, they were promoters. They're bringing less to the table now for an artist. And it's back in the day, Bruce Springsteen could, sing about record companies just giving me a big advance. I mean, the world has changed now. And if I were a young artist, I mean, I'm not an artist, I'm a litigator, but if I were a young artist, the choice between going to a big label and going to an indie that was more tailored to what I needed would be the major decision for me.
But and the other thing that's really interesting, because I really want to ask you a serious question, but if you don't mind. Seriously. But no, but I mean, don't forget, this is the first year there may not be a platinum album.
What's that?
This may be the first year that you don't have a platinum album by a band or a solo performer.
right, it's not-
But
not yet this
I have a serious question for you, Jill.
Me?
Yes.
Okay.
But I mean, and I can ask this question because we're right near the state of Virginia, or the Commonwealth of Virginia.
Okay.
But I mean, I've been watching Sonic Highway, which I love, and I've watched how the Foo Fighters have kind of ramped up the album, and they did the Letterman thing, which was wonderful, and obviously a big part of it is because they're unique people who can do that. But I mean, to some degree, is that because the Foo Fighters are trying to adjust to a new marketplace and promote differently? Like, for example, 10 years ago, that would be the #1 record in the country, would be on every radio station. Has their migration to television been kind of a reaction to a changing marketplace?
Yes and no. I think that the last album was, when they went in and they did when Dave did the documentary on Sound City, he was thinking about and back and forth even, the documentary before that, he was thinking about how do I focus people on the fact that the Foo Fighters are about to release another album. This time, I think what's happened is he's gotten into the love of the process of being a writer, director, producer, and I think this might have happened even without an album, but so I think the answer is yes and no, it's both. But rock in particular is suffering right now. I mean, it's really tough to market rock and roll. There's, when you turn on the radio, I personally am a rock and roll fan, and I have to usually scan through almost the whole dial in any given city to find a rock station anymore. So I think particularly rock artists are having to get creative in terms of just letting the world know they have a record out. They probably have old fans that are looking for it, but I don't know how much of a market is growing in rock right now.
Right. And the shame of it all is that there's very few. I'm not trying to knock the Arcade Fire because I love the Arcade Fire, but I mean, because I speak fluent Canadian, but that's a different story. But be that as it may, I mean, we don't see new rock bands. And I tell you, I've seen some of the best rock bands in the last couple of years, and no one knows who these bands are. And Casey can agree with me because he's also a Wolves in the Throne Room fan, which is the best band I think I've ever seen in my life, and I've seen everyone, and no one knows who they are. Because these guys can't make money playing live. They can't sell records. They sell merch, and they're on Southern Lord Records. Anybody know Southern Lord from Los Angeles? Yeah. I mean, that's like probably one of the few independent record labels that can actually make money. And as a matter of fact, it's one of the guys from Scream works there, right?
Yeah, but that's the problem is that it goes back to what you were just talking about and what I was just thinking when we were all talking about major labels and what's happening and whether we would sign to an indie or sign to a major. I mean, I think the truth is that the majors can still break bands if they decide to. And whereas the indies really never could consciously, purposely break a band.
There are artists who are made from indies, and there are artists who are not made from indies.
Yeah. But I disagree with you that there's no good new rock bands. I think there's lots.
No, you misunderstand me.
Yeah.
I'm an obsessed Wolves in the Throne Room fan, believe me.
But also because I'm very supportive of indie labels, but it's important to know majors and indies, it's still, some indies, just have a lawyer draw up a very stringent contract that could look like a major label contract. And just because someone's called an indie label doesn't mean you're not going to also find a contract that's going to be, that's not going to work for you. And also, at that point, you're making less money. They still want to own it. There may be no marketing monies behind it. One of the things I have a big issue with is they'll say, oh, we'll share with you 50-50 net receipts. But there's this thing that we haven't talked about called mechanical royalties, which is the publishing royalties that are paid from the first record sold. Record royalties, you have to wait until all the costs that the record company pay on your behalf, the advance, whatever, independent marketing, and you have to wait for them to recoup that before you earn any money. Your publishing monies are paid from the first unit sold. And a lot of these net profits deals say your net profits are inclusive of your publishing share. Now, most artists don't find themselves ever making a profit. So, if you're selling a lot of records, great, you're going to make a lot more later. But if you find that you're in that middle place where you're not selling enough, now you just gave up your publishing money.
Right.
And that's a lot worse. So, like someone just came to me with a contract and they were like, oh, we had someone look it over for free. We didn't really want to pay a lawyer. I mean, and if you saw the comments that were made, they were arguing that they should have the right to audit 3 times a year, as opposed to worrying about how many records the mechanicals. The person didn't understand the contract, and there's a big disservice done there.
Right.
And, so it's very important that anytime you're signing an exclusive deal that has implications that go beyond a record or a term management deal, whatever that deal is, that you have someone experienced review it for you, because these things, will affect how you can conduct business later in your life.
Yeah, but what I find terrifying is that the 2 things Larry Lessig never understood was mechanical royalties and the Berne Convention. But that's a different story. But one of my proudest moments is when we'll talk about that afterwards. But he actually lives in him. He's not a bad guy and a Red Sox fan. But by the way, the thing that really frightens me more than anything else is that if we've seen royalties get squished, I've always believed that fundamentally even the smallest band or a marginally successful band could make money in mechanicals. At least they had something. And I think that, as we've gone to the streaming universe, and we've seen, David Israelite and those guys at the Publishers Association are fighting for the rights. They want to, do away with the rate court and everything else. And I respect their opinion. David's a nice person. But as someone who's worked with a lot of artists in my time, I think the evaporation of mechanical royalties are terrifying to me. And that's the one thing you really give up in the streaming universe, because as you well said, you're not recouping the mechanicals. You get them, you may not get them immediately, but you may get them over the course of a year.
Let's say you're an artist that does it right, then you don't get mechanicals either. So, they're,
No, but you know what I'm saying,
yeah, but yeah. And that's why when they try and take touring and everything, and a lot of people, some people feel records should now be out there and free, unless they get the money will be made on merch and on touring and other income streams that you may make. But, not everyone's that type of band that they can tour in front of a lot of people. And,
right.
Every band's different.
And not just that, and I will say this, by the way, there's 3 women in this panel, so I can say this. But you know who's discriminated against the most in this world is women.
Women, yeah.
It's been no, it's true. It's true. No, it's true. And I'll tell you, I think women have come out of this the worst. In the one genre that I think has been affected more than any, the Cowboy Junkies, the band from Canada? My friend's wife is in the Cowboy Junkies, and yeah, she's married to Graham Henderson. She's married to Graham Henderson. But the Cowboy Junkies are the nicest people in the world, and we hang out, and the Timmons family are nice people. But you talk to women who are like singer-songwriters in that genre, they've gotten killed. And the thing about it is that most of these women write their own songs, and people say, well, you should go on tour. But I might have kids, I might have a husband. I may want to stay home. Why should you force some woman to go out on the road? And frankly, it's not like being Metallica. That's a tough genre to market. And I just feel I subscribe.
Well, there's not as many women. I do a lot of work in the festival market, and we see when we're trying to stream, the number of women bands or soloists that play on these shows, these festivals, are very small percentage.
Yeah, we basically.
There aren't many people that can get
essentially a genre has been wiped out to a certain degree, and there was a lot of good music came out of that genre. All right, so
tell their husbands to stay home with the kids.
There you go.
That's what's happening these days.
Well,
that's right.
You sound like my mother.
There you go, exactly. What I was saying. What about the men? Don't they need to stay home with their kid and don't want to tour? Now these days everything's changed. It's a different world.
Hey, by the way, if anybody went, another thing, I want to digress for a second, but what I found particularly, one of my best friends is 5 years old, and she's going to go, and her mother teaches at Boston Latin, but.
And he learned the other 40% of what he knows from her.
Yes. But I was inspired by the girls' camp stuff. And when she's 7, she's going directly in. But that's a great. I don't want to sound like a feminist or anything. But I just find But seriously though, But seriously though, I'm digressing here. But but the camps for young girls who want to play music, I think is a good thing. And I'll digress again if I may. I'm just going to say this, and I don't care what anyone thinks, but my friend's daughter, and I will not mention her by name, she's 14 years old. Not that we play hockey where I live, but she's an incredible hockey player, and she's a wonderful, wonderful young woman, and she's being bullied in school. So being an Irish guy from West Roxbury, my first inclination is tell me where the girls are, I'll send someone over the house and talk to them. But I just think that, what Michael Bracey has done in this organization is bringing these organizations in. Jenny Toomey obviously is really the mastermind of what we've done, but just to digress, I mean, we've been part of an organization that's helped empower girls between the age of 7 and 13 to learn how to play music. I just think that's good. So, now, getting back to the subject. So other than, obviously I'm gonna do the Sound Exchange plug, because sorry? Oh, no, but I just want to, no, but we haven't got to that point yet. We will, and you'll be the first person I ask.
Yes.
Oh, I'm sorry. Good question.
Yes. There's two copyrights in music generally that we deal with. I mean, there's the copyright in the sound recording, which is the master, which is the embodiment of a song on a record, vinyl or CD or whatever. And then there's the underlying words and lyrics, which is the song, and that's the copyright in the song, right? So there's the master recording, and then there's the musical composition.
Yeah, in other words,
so mechanical royalties are what's paid for the right to reproduce a song on a record. So it's paid for the use of the musical composition on a record,
Yeah.
and then
To the writer.
to the writers,
Yeah.
to the
In
writers.
in other words,
And then the record royalties are paid to the performer, the artist, for the sale of a record.
And the mechanical royalty rates are predetermined. The Copyright Arbitration Royalty Panel sets those rates, and they don't set them very often, so they're not negotiable. Yes.
Yeah.
right. In other words, when Frank Sinatra does My Way, there's two royalties. One is Dean Kaye, who wrote My Way, not My Way, That's Life. So when you hear Frank Sinatra sing That's Life, the songwriter, whose name is Dean Kaye, is paid for that, and then Frank Sinatra, who of course is Frank Sinatra, gets paid for his recorded performance of the songs. There's always two royalty streams: the human being or the human beings who wrote the song, and the human being or the human being who actually performed the song. Okay, I'm gonna get back to this in 1 second. I just want to.
It doesn't get paid for the recorded performance in the underlying, in the embodiment of the record, but not for the public performance.
Are you trying to give Frank Sinatra a hard time?
I'm giving you a hard time.
Well, I think your point that we're speaking a foreign language here is well taken. I think you should also say what a performance royalty
please,
is.
go
Okay,
for it.
so there's a mechanical royalty, as you was just explained, that's for the reproduction. But when you play a song in the public, that's also an exclusive right of the copyright holder. And in publishing for the composition, that's called a performance royalty. And so anytime Frank Sinatra's song is played on the radio or on television,
Macy's, or any store you go to,
or in a concert, that earns a royalty for the songwriter,
Right.
the composition owner. It's more complicated for sound recordings, and that might be where you're going next.
You have to give the background.
Well, you know what? Excuse me. We wanted to talk about pre-72s, but I think this is becoming too complicated.
That's very good.
So I think I'm just going to end with a thought and then open it up to so all of you can participate in our discussion. But my premise is this: the only part of the recorded music industry that's growing is sound exchange.
Is what?
Sound
This
exchange.
is what sound exchange. So there's traditionally been this public performance right in the musical composition. There hasn't been in the United States. There isn't a complement on the sound recording side. So when a master is played on the radio or in clubs or in stores, there is no money paid to Frank Sinatra for his performance on the master or the record label. So I guess about 10 years ago or sometime, there was a statute that came into play having a public performance right for sound recordings in digital services, which is what Walter's now going to get into. And out of this came this sound exchange, which collects this master recording performance money on behalf of artists and labels and distributes it to people. And this whole thing that is way too complicated about pre-72 and post-72 has to do with whether or not there actually is a performance right in sound recordings at all. and how that should be paid, but just at least so you know what sound exchange
Yeah, I mean,
is.
basically the two issues of this. The United States, North Korea, and Iran are the only countries in the world where where recording artists are not paid when their music is played on the radio. And the other issue is that because the United States did not enact copyright protection for sound recordings until Valentine's Day of 1972. It was
72.
72, but I think it was Valentine's Day.
No, actually, I'm a nerd. It's February 15th.
Well, it makes a better story, though, Paul. It makes a better story. But the thing about it is that the folks who recorded before 1972, are kind of left in the lurch. So some of our great music, be the,
Most of our great music.
well,
The Beatles.
point taken. But I mean, but again, those folks have been disenfranchised. So there's been a big fight about, how do we help our legacy artists? Ray Charles, Charlie Parker, Clifford Brown. I mean, how do we help these people get their royalties? Be that as it may, I'm going to open this up, and anybody have questions? We deliberately have tried to make as much time for questions as possible. So,
I have a question, and it's something I noticed. It's come up in the last several months, and the fact that evidently, the fact that at least one publishing house has pulled back its rights from BMI and ASCAP, and has decided to take on that role itself, and the fact that BMI and ASCAP are challenging the consent agreement that's been in place since the early 1940s, with rate, it's not just rate rulings, it's like challenging the whole agreement, and it's sort of like 52 card pickup, and I'm just concerned that, be careful what you wish for, you just might get it, as far as the PROs are concerned. I'm seeing that, of course, nothing much is coming in, but I see, when you open up the consent agreement to comment, like it happened this past summer to the Justice Department, I'm sure maybe there were people that sent in comments about paying the PRO fees at venues or something like that. It brings it all up, and I'm just curious what each of you four, or actually five, thoughts are about the whole thing. Thanks.
Well, I've actually I've litigated for ASCAP in the rate court against YouTube, actually. What has happened is, with the rise of digital performance of music and tech, the consent decrees have proven to be not good structures for determining the value of music on these services. They're also hampered by the fact that each BMI and ASCAP, there is only one judge for each of them that hears all the rate court cases. Pardon me? No, Southern District of New York, yeah.
in Westchester?
No, in New York. It's Judge Coate for ASCAP and Judge Stanton for BMI.
And they sit in the Southern District in Manhattan?
Yeah.
Okay.
And it's one judge and hears all the cases. And there's been an enormous amount of frustration over the last few years because a real perception on the part of the PROs and on their members, and some of their members are very strong, like Sony ATV, who you mentioned has pulled some digital rights, that they haven't been able to get a fair hearing.
Yes, well, that's...
Well, it varies. Actually, in BMI, I think it had to be all of them, and and the judge who sits for ASCAP said they could just take the digital out.
And the problem with all rights, one of the reasons the PROs exist is because all these clubs and all these restaurants and all the places that play music have to be licensed, and it's a little difficult for the publishers to license directly to all of these gazillion places. So if they were trying to pull out their digital rights because a lot of services online don't have deals with the PROs, and it makes it hard for the publisher to grant all rights inclusive. So they wanted to just pull out their digital licensing rights. But now they're being hampered because they're being told, you can pull them out, but you have to pull everything out together, which would mean you now have to figure out how to license directly to all these clubs.
See, one of the problems that the PROs have had in the rate courts is getting the court to recognize that a lot of the digital services are building their service on the back of music. And if they're not, they may not be revenue producing, but there's a value, there's basically equity value in using the music to build up these services. And the courts have been very resistant to that.
Part of the thing is the law is so far behind, and Congress can't even pass a budget or whatever.
Yeah, I
Good luck. I mean, I think it really has to go back to the basic law, but good luck on that.
Yeah, I mean, a few years ago, ASCAP had a slew of rate court proceedings. Right now, I believe there's just the Pandora case. I mean, they've cut way back on litigating rates. They'll settle everything. I mean, they work out deals, and then they pursue the DOJ on renegotiating the consent decrees, and they're lobbying in Congress.
But the issue really is, though, that if you have a big catalog of musical works, wouldn't you rather negotiate directly with the intermediary as opposed to having ASCAP and BMI do it for you? I mean, that's really where we're heading. But you had a question too, so.
Hi, I'm Thomas Janine. I'm an attorney in Baltimore. I think one of the keys going in the future is this wonderful hybrid of the interactive stream, whether we like Spotify or not. It does pay that performance and a mechanical. So my question is, where do you think these rates are? I think the compulsory statutory rates expire at the end of 2015.
Well, they don't apply to interactive.
Right.
Interactive,
rates, yeah.
but where do you think the mechanicals will go generally?
Up.
I mean, I know that's a big one, but I think it's pretty key.
But don't forget, though, Spotify doesn't pay people.
I understand that.
Okay.
Yeah, but
No, but I just want to make that clear, because Spotify is a bad thing.
that could well be.
No, but it is. But I mean,
Okay,
it's a
but
bad. No, let me say one thing.
Yeah.
Spotify is a bad idea that never should have happened, because Spotify loses money, and all Spotify has, and it's not run by nice people, by the way. But all they've done is destroy artist royalties. So I mean, this is a very anti-Spotify rule.
No, I'm not pro Spotify.
Okay.
All I was asking is, where do you think the mechanical rates are going to go,
Up.
and when, and how high?
This big fight between the RIAA and
11 cents.
It depends on what the CARP says.
Right. It'll be 11 cents
People
in
who
5
don't even
years.
really
Isn't
know
there a
the
big
difference.
fight right now between the RIAA and the publishers? I mean, where the RIAA is trying to get a rate and then license on behalf of them, and they kind of want to keep the traditional, where the record label gets the bulk of the money.
But we've seen this
And the
movie
publishers get
before.
saved.
This happens every 10
Yeah.
years. And I mean, it's going to go up. I mean, it's going to.
It's like the services happen, and at some point, people are just going to have to decide on some money. And
But that's just it. You just nailed it. It happens every 10 years. Every 10 years, we decide what we're going to get paid. It's like Section 8 blighted housing. It's pre-negotiated, and we don't.
Right.
For 10 years, minimum wage goes up, you
Right.
know.
Well, hopefully.
but not our royalty rates.
Yeah, the question
That's
is, I mean, it'll go up. The
pre-negotiated.
question
It's
is, will anybody actually, will we live in a world in 5 years where mechanical royalties still pay people's rent?
It's of diminishing significance,
Yeah.
just given where the technology is.
Right. I think Nelson has a question.
I have a question, man.
Oh, I'm sorry. Sorry.
Walter, you mentioned something at the beginning of the panel, which I think was very important to the standards of legacy artists and royalty, the Ellington case that was decided on Thursday by the highest state New York court. I'm wondering what you think about the application of the sort of forward-thinking language barrier that they set forth, in that I don't know how many of you have actually read that case. I know you probably have on the end, and Walter obviously had,
Yeah.
and Ashlye, this is something that applies greatly to certain artists inside the New Orleans
Right.
sector. So the Supreme Court's kind of set a standard in the bar, challenging the language, saying that there was no forward-thinking language which applied to the applicability of the assignment of licenses for royalties. And I'm wondering how you see that affecting what you do inside the context of your publishing deals going forward in the future, and the application to already other legacy artists. artists?
That's an awesome question.
Well, just to give
Yeah, I mean, that's a
a
great
little
question.
background about what the Duke Ellington case was about, the Duke Ellington heirs sued Sony ATV, claiming that because their contract dated back to, I think, early 90s. And at that time, what the contract said was that the publisher had to pay, with respect to foreign royalties, 50% of its receipts in America.
Right.
And it was, and the contracting party was defined as the American publisher and its affiliates. Well, since that time, Sony ATV is the successor to Mills Music, which was the publisher at that time. The publishing world has changed, and American publishers now own, by and large, the large publishers, the foreign publishing houses. So the argument was, well, because of the use of the word affiliates in this old contract, obviously the intention was if an affiliate got the money, I got 50% of that money.
Right.
And what Sony said was, no, affiliates was used back in 1990, and it only applied to the affiliates who existed at that time. So Sony UK can take 50% of a dollar earned and pay Sony US 50 cents, and Sony US only has to pay its writer 25 cents because it only has to pay 50%
Right.
of what it receives in the United States. And the highest court in New York, this again is similar to what I was talking about earlier, the courts, especially New York right now, have gotten, they will not often look at what the larger intent of a contract
They
was.
take the public policy out of the equation.
Exactly.
Just to
But-
clarify something.
Wait, I think.
They went against
Yeah,
the Duke.
let me,
that's
I think,
actually
Well,
I-
it was done in 1961.
right, but
Ellington's-
let me just do this if I may, and I think Paul could back me up on this. It's called the Swiss twist, is that what it's called? But, I mean, the irony of this case, in my opinion, is that, Sony ATV also controls the publishing of a band you might be familiar with, they're called the Beatles. And no group of individual has been more penalized in the publishing world than the Beatles. There's a great book, I recommend it to you, you can buy it on Amazon. It's one of the 2 or 3 best music books I've ever read in my entire life. It's called Northern Songs, and it's the history of the Beatles publishing. Have you ever read it? It's incredible. But I mean, you should read this book because it gets into what happened with Mills Music and people like that. I mean, essentially, what they were doing was saying, like, if the Beatles sold, 10,000 records in Switzerland, then they somehow got robbed of their publishing rights. But the same thing happened to the Ellington estate.
But I actually managed
As
Duke
the
Ellington
No,
estate
please.
from
No,
1996
please.
to 1998. And I just wanted to clarify, the contract was done by Duke Ellington with Mills Music in 1961.
That's right. I misspoke.
Yeah,
Yeah.
and so what happened was in 1998, they issued a new standard of royalty payments in which
Right.
they gave them to the Ellington estate. And the Court of Appeals said, well, since you didn't raise any problems
Right.
since 1998 and you're raising that issue now in 2010,
Correct.
then you sort of waived that right. But the interesting thing about that case was the chief judge of New York State Court actually was a minority dissent on
Was
that,
it
in
one of
which
the
he used a
dissenters,
reasonable standard,
Right.
I believe. But
Yeah.
No, you're absolutely, thank you.
Can
You're
I give you a
absolutely correct.
practical answer to the question, though? When you sign a publishing deal, you need to make sure that the words, I'm using finger quotes on purpose, at source,
Exactly.
needs to be in the
Right.
definition of payments.
Right.
At source is distinguished from a receipts-based publishing deal. If the earnings at source are $1, the record and the publishing company agrees to pay you 75% of at source earnings, that's 75 cents. If the publisher agrees to pay you 75% of receipts
Right.
earnings, then it's the calculation that was just explained, where it's 75% of what is received by the publisher from the affiliate, from sub-publishers, wherever. So critical to remember, at source.
And
And I mean, the sad thing about it is, in 1961, no one was thinking
Right.
source.
That's why you have to.
And there was no failing by Ellington's
that's what-
lawyers at that time, but it's
That-
an
that's-
old contract which still.
That's why you have to
regulates.
read this book, and the legend is that the person who invented at source was Eastman, because
Yeah.
of the Beatles. That's the
John.
legend. But I
Yeah,
mean,
well, that's
but you
interesting.
really, honestly, you should really read this book. It's so edifying. It's unbelievable. Are you next, Nelson? Why don't you go
Let's
for
say
it?
also the writers, though, also back in the day, they capped their mechanicals, what we were talking about, and they got a percentage of whatever they earned, and they were determined at the time of the contract. So some people are only making 2 cents a song, as opposed to what's typically now 9 cents a song. Now, with digital, they've now, because it's a different type of use and it's not under the statute, they're, the legacy artists, if they're in the digital services, are finally getting paid potentially fairly on those amounts, but they've gotten squeezed everywhere in the publishing world.
But to your honor, though, I remember when we worked together, you put on a huge fight for an artist who will go unnamed over his mechanicals in this issue, who will remain nameless, but he's someone that we all love. But, all right, but I mean, I just wanted, this is just the type of,
Very important income stream.
it was Iggy. But I mean, this woman went to war for Iggy, and we love Iggy. And she went to war for him over his mechanicals, for that alone.
Well, we've all gone to war.
But no, but I mean, it was a personal crusade to help Iggy, which, Iggy is everything to us, so. Nelson Jacobson.
So on the other side of that, I'm in a company that signs digital and physical distribution deals every day of the week, and the point that no one reads these contracts should just not, and I'm not talking about the artists themselves, I'm talking about Congress, I'm talking about your local leaders. There is a total dysfunction of understanding the legal ramifications, and your judges can't rule on this because they don't know. They are asking a 30-year-old clerk whose entire existence has been with white earphones, and they think that's how everybody else is, and that it should be free. And this is a weird conversation, and we have it with our trade people. I talked to a deputy secretary of trade last night, and I said, do you realize we don't support US-made music? And he's like, well, we don't make music in America anymore, kind of comment. And he's like, we know the factories are there, we know that, but it's 2 and 2 aren't going together. And the other point is, every single one of our contracts are breached almost the moment it's signed. And we are now in this weird world where you guys know this stuff, we know it, but the artists don't know it. Their managers definitely don't know it. And we're now stuck because going to court is it's really not helping anybody but the court system. It's not even helping lawyers sometimes because you can't even get to court because of the malaise that's here. And somehow we're going to have to go back. I don't know if it's a future of music issue, but we're going to have to get people to start thinking about block and tackle, like this copyright was put in the Constitution for a reason. And your point about, I say this all the time, if I was launching an app that stole music, I could get funded tomorrow. If I'm telling people I'm making music, people will laugh in your face. So.
Because the safe harbors.
Well, it's easier to steal music than it is to buy music.
Right.
I mean, when you think about it, one of the problems that I see is if you go to Walmart, if you want paper towels and you go to Walmart, you can buy paper towels, okay? And if you want to wait a couple of days to clean up your mess, you can order them online from walmart.com. You can get a suit at Dillard's, but you cannot buy records from record labels. You can't buy records from record labels, and you can't go to a record store because they're all closed down. So you have to go to iTunes or Amazon or wherever else. And that's one problem.
Well, they're not all closed down.
Not all of, okay, but look, there's like 3 in the state of Louisiana. 3.
Disc makers made more CDs last year than they did in their company history.
Vinyl's back.
And
Well,
vinyl
sure,
went from
but
0.08% in
let's-
2008 to 5% last year.
But let's be-
Cassettes are back. So CDs are 52% of sales right now.
Yeah, and
Digital
other
is
people's
43.
cassettes.
I'm holding out until they bring
What,
back
one
the
thing you said,
8-track.
though, that has me, that's scary, is as a lawyer trying to protect, everyone expects everything to be sewn up in a neat little box, and that you're protecting them from being sued, and there's no way to sew anything up in a neat little box.
Right.
Every day, people are infringing because you can't get all the rights. I work with festivals, and I don't know what song a band's playing in advance, so if I'm streaming their show and it's delayed by 5 minutes, at that point I made a record, I'm supposed to pay a publisher a sync license, I'm supposed to clear it, but I don't know the song in advance, I don't know all the writers, there's no way for me to do that. maybe I have to pay unions. There's all these people, they want me to pay the performing rights societies myself. I can't go negotiate in every country on behalf of the service to get a performing rights license. So, you can do what you can to sew up the rights, but you're going to be infringing in many ways. And a lot of us, and you got to hope that people just aren't going to sue you because they can. And often there aren't. I mean, the labels are not just suing because they can. I mean, a lot of times it's the small person that's suing on advantage as opposed to the bigger groups. And, that's a scary thing for us because, Bridgeport, some of the small publishers, and because it's not even like you're not trying, but it's not always possible to do that.
I think you have a question.
Thanks. Yeah, this has been a great discussion. I'm from Nashville, so I wanted to touch on the comment that rock is dead or not, really a vibrant scene, because we have a huge rock scene in Nashville with Infinity Cat Records and Nashville's Dead. And they've done a really great job just building community. I mean, they sell a lot of 7-inches and cassettes to get back to actually selling music, and they put on a local festival, so it's not dead. I also had a question, though. I wanted to say, we have 30 Tigers is in town, and they've got a new model, and I think it's really cool, and I wanted to hear your thoughts on it. You keep your masters, and then we sell you label services for a fee or a percentage.
It's great if you have the money to market. I mean, as Joel was saying before, some of the problem is you have to get to radio, you got to get things heard. There's it's how do you get found amongst all the millions of things that are out there? You need publicists, you need marketing people. So 30 Tigers is great. They may give you an advance, and they'll want you to match that in marketing monies. But once you spent the money now to manufacture your records and to record your record and have a little for marketing, how do you get people to find it and to buy it? And so that model, doesn't work for everyone because you have to have enough of an audience for that to make sense. And that's why Joel was saying before that sometimes people still have to go to these labels because they hope, if something's happening, they have the power to spend behind it.
Yeah.
So there are great models, but those models don't necessarily work for everyone because you have to have some ability for financing. Now, Kickstarter and stuff, these things are really interesting because they do help people with financing where they don't otherwise have it.
Yeah, but the dilemma of Kickstarter is, in my experience, is that most of the people who've been successful in Kickstarter are bands who already have a brand. Like Mission of Burma did a Kickstarter record. I mean, but it's that's the problem for young kids. It's hard to do a Kickstarter project because no one knows who they are.
If you can do it yourself.
Yeah. All these angst-ridden teens with trust funds, putting out their records, that helps.
We're done?
Okay.
Oh, I'm sorry. We have to stop. I'm really sorry, but I really had a wonderful time. I want to thank our 4 phenomenal panelists. I owe them a great debt of gratitude for doing this. If I could just conclude, I want to thank Casey again for encouraging me to do this. I think the world of these 4 people. They're not just great attorneys; they're great human beings who all love music. And thank you. I also want to thank you folks for asking great questions. So thank you very much, and I hope you have a great time. Bye-bye.